On May 6, 2025, a preliminary examination took place in Judge Michael M.C.N.'s courtroom at the Woodhaven District Court in Woodhaven, Michigan. The prosecution was led by attorney Mohammed, while the defendant, Sergio Bello, was represented by attorney Lillian Dio. Before we get into the details of this hearing, it helps to understand how Michigan's court system works. A preliminary examination, often called a prelim, is a key step in felony cases. Here, a district court judge listens to evidence presented by the prosecution to decide whether there's enough proof, known as probable cause, to move the case forward. If the judge determines probable cause exists, the case is bound over to the circuit court, which is responsible for handling felony-level offenses. In this instance, Mr. Bello faces two serious charges: assaulting, resisting, or obstructing an officer, and third-degree fleeing and eluding, both felonies under Michigan law. It's up to the prosecution to show Judge M.C.N. that sufficient evidence exists to send Mr. Bello's case to the Wayne County Circuit Court for trial.
Any other preliminary matters? Mr. Mohammed?
No, not from the people.
Ms. Diallo?
None, thank you.
Thank you. Call your first witness.
People call Officer Gregory Brewster.
Okay. Officer, stand up, please. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do.
Okay. It's Gregory?
Yes, sir.
Brewster.
Yes, sir.
Okay, Mr. Mohammed, you can proceed.
Thank you. Good afternoon, Officer Brewster. Can you please restate your name to the record?
Lieutenant Brewster, Trenton Police Department.
Okay, Lieutenant Brewster, are you currently employed?
Yes.
Who is your employer?
Trenton Police Department.
And in what capacity are you employed there?
I'm a patrol lieutenant for the police department.
Okay, and were you employed in that capacity as a patrol lieutenant on January 26, 2023?
No, I was a patrol sergeant.
Okay, and on that day, did you work?
Yes.
On that day of January 26, 2023, did your duties as a police officer take you at or near the location of 1875 West Road?
Yes.
Is that located in the city of Trenton, County of Wayne?
Yes.
What took you to that location?
I was there for an unwanted subject.
Okay, and what is at that location?
It's at a gas station.
Okay, and upon making that location, what did you do, if anything?
I made contact with the clerk who called.
Okay, and what did you learn?
Oh, I'm gonna object this to hearsay.
Any response?
Judge, I didn't ask about any specific statement. I'm just asking the officer what you learned since his investigation.
At least it's overbroad, sustained, rephrased. Is this the gas station on the corner of Fort and West?
Yes, sir. He Kings Mobile.
Thank you.
Okay, so sir, you indicated you had contact with the clerk?
Correct.
Okay, why did you have contact with the clerk?
That was the call.
Okay, and after having contact with that clerk, did it have any effect on you? Did it cause you to make your next decision?
Yes.
Okay, Your Honor, at this time, I think the statements by the clerk would come in under effect on the listener. The officer indicated.
We'll ask her next question, and she can object if she wants.
Okay. Officer, what did you learn from the clerk that caused you to further your investigation?
Wait 1 second.
So Judge, I am gonna object to hearsay. So I think the way we might do this is based on what you learned from the clerk. Did you do something as opposed to her words
Assisting, assisting.
Okay, officer, based off of what you learned from the clerk, did you do something based off of those statements?
Yes.
Okay, what were the statements that that had an effect on you and caused you to change your steps?
She told me.
Wait, no, that's hearsay.
Sustained.
Thank you.
I'll just move.
What did you do next, sir? After speaking with the clerk, what did you do next?
I made contact with the person that the clerk called,
And where was that individual located?
standing next to a vehicle near the gas pumps.
Okay,
See, I could still do this, Ms. Diallo. 31 years later, I could.
How many?
31. Believe it or not. Go ahead.
thank you.
During the hearing, prosecutor Mr. Mohammed repeatedly tried to question the officer about statements made by the gas station clerk. However, Judge McNally consistently sustained. Defense attorney Lillian Dios. Objections on the grounds of hearsay. Under Rule 801 of the Michigan Rules of Evidence, which mirrors the federal and most state rules, hearsay refers to any out-of-court statement offered as evidence to prove the truth of what's being claimed. In simpler terms, a witness can't testify about what someone else said if the goal is to convince the court that the statement itself is true. For instance, if a police officer testifies that a witness told him the defendant fired a gun, that statement can't generally be used to prove that the defendant did fire the gun. This is because the original speaker in court to be questioned or challenged by the defense. There are, however, exceptions. Some out-of-court statements are admissible if they fall under recognized exceptions to the hearsay rule, or if they're offered for a purpose other than proving the truth of what was said, such as to explain why an officer took a particular action. In this case, Judge McNally ruled that the officer could not recount what the gas station clerk allegedly told him, finding that those statements qualified as inadmissible hearsay.
Okay, and the individual you made contact, where was he standing exactly?
Next to the vehicle.
Okay, can you describe the vehicle?
This is a red Fusion.
Okay. And was there anybody that was sitting in that vehicle?
No.
Okay, was there anybody else besides that individual standing outside of that vehicle?
No.
Okay, now that individual that was standing right outside of that, was it a Ford Fusion?
Yeah.
Standing outside of that Ford Fusion, do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that individual's wearing?
A black suit coat.
Your Honor, please let the record reflect the witness has identified him.
Record should so reflect.
Thank you. And did you initiate contact with that individual that you just identified when you were at the scene on that day?
Yes.
How did that begin?
I don't remember my exact words, but I think I said, "Hey, what's going on?" Or
Okay.
how's it going?
What happened next?
The radio in the car was very loud, and I believed it was going to be difficult to have a conversation with the person. And I asked to turn the radio down. I said, "Can we turn the radio down?" Something to that effect.
Okay, besides that, was there any other observations that you made?
When I first made contact with him, I noticed
And who's him, just for the record?
the defendant there.
Okay,
When I first made contact, I noticed that the person was unsteady on his feet and he had red eyes, red bloodshot eyes.
okay, and based on your training and experience as a police officer, what is that indicative of, if anything?
I believe that he was under the influence of something.
Okay, and so what happened next?
Against my better judgment, he sat in the car to, I believe, turned on the radio, but that's not what happened.
Okay, what happened next?
The person attempted to put the vehicle in drive and
Oh, okay, before we get to that, where did that individual sit?
dressed.
Okay, at that point, was the vehicle on or off?
It was on.
Okay, and after that individual sat in the driver's seat, what happened next?
The person put his foot on the accelerator and tried to put the vehicle into gear.
How do you know that?
So I saw it.
Okay, and what happened next?
I told him to stop twice, very
Okay,
loud,
okay, and why did you tell him to stop?
because I believed he was trying to leave.
Okay, and when you told him stop the first time, did he say anything in response or do anything?
No,
Okay,
he continued to try to put the car in gear.
okay, and what about the second time? What happened after that?
Same thing. He continued his actions,
Okay, and what was his actions that you were observing?
that he was trying to put the vehicle in drive.
Okay, what happened next?
The vehicle got into drive and the driver of the vehicle left.
Okay, and the driver of the vehicle, just, I wanna confirm for the record, that's the same individual you identified here in court?
Correct.
Okay, and what happened after that?
The vehicle drove east towards one of the entrances / exits to the gas station onto 4th Street.
Okay, And do you recall what the posted speed limit is on 4th Street?
On 4th Street, it's 50 miles per hour.
Okay, and based off of your observations, what did you do?
My vehicle was parked on the opposite side of the gas station. So I ran back to my vehicle, got my vehicle.
So just so I know, you were on the west side of the building? Is that where you were?
My vehicle was parked on the west side of the building. I walked into the gas station and then I walked out.
So now when you were confronting him, you were on the east side of the building?
Correct.
He pulled out and started traveling southbound on Fort?
No, northbound.
Northbound, okay.
And you indicated that the posted speed limit in that vicinity is 50 miles per hour?
On 4th Street, M85, correct.
Okay, and what did you do next?
I ran back to my patrol vehicle to get in and attempt to pursue.
Did you attempt to pursue him?
I never turned my lights on. I thought I saw the vehicle turning north onto now the northbound lanes. So my assumption was that the vehicle went.
You may object to speculation.
Okay, so you can testify and I'll keep on record that portion up to my assumption was.
Okay.
All the rest is strict, that language is stricken. You can ask your next question.
I would agree that it is. And so what did you do after that?
I saw a vehicle turning from eastbound West Road to northbound 4th Street. I believed that vehicle was the vehicle that I was after, because I saw taillights of that vehicle turning. So I drove south on the 4th Street to hit the turnaround to try to catch back up to it, to go back northbound and catch up to that vehicle.
Okay,
There's a no left turn signal there, is there not?
Yes.
So in order to turn from eastbound West Road on the northbound Fort, he had to disregard that signal, correct?
Yes, sir.
And you turned back southbound on Fort, did the Michigan turn, and now we're heading back northbound on Fort.
Yes, sir.
okay, and were you able to locate that individual, the defendant?
No.
Okay, and so did you learn anything else pursuant to your investigation?
I returned to the gas station and spoke to the clerk.
Okay, and what did you learn?
Oh, no, I would object just to hearsay, anything she said. Thank you.
I learned that
Wait a minute,
What-
slow
hang
down,
on.
slow down.
Judge, I'm not asking for a specific statement, so there's no specific out-of-court statement. I'm just asking also what you learned pursuant to his investigation.
Any response to that?
I think you can ask, and this is just me, I don't know, it's up to the judge. Based on your investigation, what did you do next without saying the specific words? Because we know hearsay is a statement offered by the declarant, other than while testifying at the trial or hearing, offered to prove the truth of the matter asserted.
Wow,
I've been 30 years too, Judge.
go ahead,
I would
Mr.
agree.
Muhammad.
Officer, based on your investigation, what else did you discover based on your interaction with the clerk?
I learned that I went the wrong way and was pursuing the wrong vehicle.
Okay, and did you learn the correct way that the individual fled from the scene?
I learned that the vehicle went, I saw the vehicle turn north onto southbound 4th Street, but I learned that it did not go that way. It went west on West Road.
Wouldn't that be hearsay, Judge? What you learned? Because you have to learn it through hearsay. So I would ask that that be stricken objection hearsay. And speculation.
And Judge, I would disagree. I think there's no specific out-of-court statement that's being offered. I think the officer is just testifying to what he learned pursuant to his investigation. There isn't a specific out-of-court.
You have to bring it within an exception or he'll argue it isn't hearsay.
Well, I guess my first argument is that it's not even hearsay because there's no statement. But if the court is implying that it is, then
Wait a minute, how's there no statement? If he learned after talking to her, no matter how you phrase it, he learned based on her statement, right?
He learned pursuant to his investigation that the individual had turned a different way. But hearsay is when we're introducing a specific statement. There isn't a specific statement that the officer is testifying to. He's not saying John Doe stated X, Y, and Z. He's just saying, I had a conversation.
It's still based on hearsay, no matter how you cut it. Otherwise, you could get around the hearsay rule every single time. Be like anybody asking anybody, what did you learn after speaking with them? That statement is still hearsay. I'm gonna find that it goes to the declarant's state of mind, and I'm gonna allow it.
Understood. Thank you.
Ask your next question.
Thank you.
Judge MCN ultimately ruled that the gas station clerk's statements were indeed hearsay, but allowed the testimony under an exception related to the declarant's state of mind. As explained earlier, hearsay refers to any out-of-court statement offered as evidence to prove the truth of what was said. Prosecutor Mr. Muhammad argued that the officer's testimony shouldn't count as hearsay since the officer wasn't quoting the clerk's exact words. However, even a paraphrased version of what someone said still qualifies as hearsay if it's being used to prove that the content of that statement is true. That said, not all hearsay is automatically excluded. Some out-of-court statements can be admitted if they fit within one of the recognized exceptions to the hearsay rule. One such exception appears in Rule 803 of the Michigan Rules of Evidence, which permits statements describing a person's then existing mental, emotional, or physical condition, commonly referred to as the state of mind exception. Under this rule, if someone makes a statement reflecting their immediate thoughts, feelings, or condition at that moment, that statement can be used as evidence that accurately represents their state of mind. In this case, Judge MCN concluded that the gas station clerk's statements were expressions of the clerk's own current state of mind at the time, making them admissible under this specific exception to the hearsay rule.
And did you learn based off of your discussion with the clerk the street that the defendant had fled from? That the defendant had turned onto?
West Road.
Okay, and do you know what the posted speed limit is at that location on West Road?
35 miles per hour.
Okay, no further questions.
Did you ever apprehend the defendant?
Me? No.
Okay. Ask your next, any cross? Do you have cross?
Just 1 second, Judge, I'm thinking, right? real
Okay,
quick.
take your time.
Just one question.
Yes, ma'am.
You weren't sure at first who the person was because it could have been a host of people. Is that fair to say? Like, you said you thought it was the brother.
No.
Well, wait a minute. The brother's name is one of the Blues, right?
Are you?
So you didn't know who the person was. Is it fair to say at first?
I did not know that.
I don't have any other questions.
Mr. Mahan,
No further questions.
you can step down, call your next witness.
No further witnesses from the people.
You have no further witnesses. What are you gonna do?
Judge, I'm gonna motion for a bind over, I believe. Testimony reflects a question of fact, the trier fact, and I'm gonna reserve any remark.
Any argument, Ms.
I
Diallo?
object to any bind over on these particular facts that were presented. We don't have identification. There are a whole host of things that are wrong with this matter. For probable cause, we object.
Mr. Muhammad?
Judge, in regards to identification, the officer indicated that he made contact with the defendant at the scene, and he identified him as being that person here in court today. I think in court identification is sufficient for probable cause. We're not here determining guilt, just whether or not there's probable cause of a crime, and I believe we've established that on this record.
Anything else, Ms. Diallo?
No, Judge, you've heard the facts of this particular case. I think I don't know what happened out there, even by probable cause standards, but I believe the officer testifies the person that he thought was doing one thing wasn't doing what he thought. It was the wrong car. It's a mess. It's Judge. We don't think there's probable cause at this stage, so for that, we would ask the court not to bind over.
And Judge, may I have a brief response? In regards to the R&O, the officer indicated that he was in full uniform and that he made contact with the defendant. He gave him 2 lawful commands, at least from what I recall, to stop, and the defendant did not stop. He then fled from that location. the officer was, he gave the defendant voice. The defendant was the driver of the vehicle and he gave him voice signals to stop. The officer was in full uniform and we also learned that the defendant did not stop and willfully fled from the scene. Shortly after, we learned that the posted speed limit on West Road was 35 miles per hour. I know in regards to learning of the 35 miles per hour, it wasn't the officer who had personal knowledge, at least did not appear that way to me. So in the event the court is not inclined to bind it over on the fleeing third degree, I would request it be bound over in fourth degree. Nonetheless, I do believe because today's probable cause, testimony is sufficient as charged. But if the court is inclined not to bind over on the third degree, I would request that it would be done in the fourth degree. Thank you.
Any response to that, Ms. Diallo?
Mr. Mohammed then requested that, if Judge MCN chose not to bind over the charge of third-degree fleeing and eluding, the court instead consider binding it over as fourth-degree fleeing and eluding. Under Section 257.602A of the Michigan compiled laws, it is a criminal offense for the driver of a motor vehicle to willfully fail to obey a police officer's signal to stop. This includes actions such as accelerating, turning off the vehicle's lights, or otherwise attempting to flee or evade law enforcement. Generally, fleeing and eluding is classified as a fourth-degree felony. However, if the prosecution can demonstrate that any part of the incident took place in an area where the posted speed limit was 35 miles per hour or less, the offense may be elevated to third-degree fleeing and eluding, a more serious felony punishable by up to 5 years in prison. In this case, Mr. Mohammed urged Judge MCN to at least bind over Mr. Bello on the fourth-degree charge if the court found that there wasn't enough admissible evidence to prove the alleged chase occurred in a zone with a 35 miles per hour or lower speed limit.
I'm talking about with his request to fourth degree.
So, hold on, I'm pulling it up right now, Judge, so I know the third degree should have fallen, with this particular set of circumstances. I'm pulling up fourth degree right now, but we still, how do we get past the, identification therein? You said you went after one car, and then it actually was a different car, so I don't know, Judge, but the fourth degree I'm trying to pull up right now.
So essentially, it's just about the 35 miles.
Yeah, but not only that, Judge, but he didn't even have his lights and sirens on. Remember, he said he didn't. I heard that. Hold on. He said he didn't have his lights and sirens on for number one. But I'm gonna pull it up right now, Judge, to see what fourth degree looks like.
And Judge, just
I've heard enough. I'm troubled here because what you have is an officer that was called, seemingly doing the right things, going over talking to a clerk, deciding he needs to make contact with the subject, goes up, makes contact with the subject, tells the defendant, in this case, Mr. Belo, that he shouldn't leave, that he didn't want him to go anywhere. But the very essence of fleeing and eluding is that he's fleeing and eluding the statement. I'm troubled because in this case, you're right, Ms. Diallo, he did not have his lights on. He was not pursuing the vehicle he was not pursuing the suspect vehicle. He didn't know where the suspect vehicle went. For all we know, the suspect vehicle, I shouldn't interject in the record, but there's an area there where you can easily get to a 25-mile-an-hour speed zone. The officer was never in his vehicle chasing him. He thought he went elsewhere. The clerk tells him something to do that is to the fact that the defendant traveled on West Road. We don't know if he traveled on West. The officer thought he traveled on Fort. He observed the vehicle that was traveling west or eastbound on West that turned left against a no left turn signal onto northbound Fort. So we honestly don't know where went and the officer was not pursuing him in a vehicle. I'm not even going to bind over on fleeing elude 4. I'm going to dismiss. I'm going to dismiss fleeing elude 3rd. However, I do believe in the face of the questions or the answers that hang on.
Sorry,
I'm not going to change my mind.
I understand.
I do believe that there's sufficient evidence, though, to establish that the defendant committed the offense of assault, resist, and obstruct an officer. How successful you'll be in a trial, I don't know, but I'm going to bind the defendant over specifically only on count 2. Count 1 is dismissed. This is interesting. I can't say I've had this one come up, but I do think that there just isn't sufficient evidence to establish he was fleeing and eluding at that time. So I'm gonna dismiss that count. Let me just make a note here, please.
Judge MCN ultimately dismissed the fleeing and eluding charge, concluding that the officer never actually attempted to initiate a traffic stop after Mr. Bello left the gas station. However, the judge did decide to bind Mr. Bello over to the circuit court on the charge of assaulting, resisting, or obstructing a police officer, in violation of Section 750.81d of the Michigan Compiled Laws. That statute defines obstructing to include knowingly failing to comply with a lawful command issued by a police officer. Based on that language, Judge MCN likely determined that there was probable cause to believe Mr. Bello disobeyed a lawful order when he drove away from the gas station, even if the officer didn't formally attempt a stop dot as of this episode's recording. The obstructing charge remains active, and the case is currently set for jury trial on September 8, 2025. If there's another courtroom case, legal showdown, or dramatic hearing you'd like us to cover, let us know in the comments below. Thanks for watching, and don't forget to like, share, and subscribe to help us promote a better informed and more justice-aware community.